First of all, thanks for joining everybody on a Friday. Appreciate it. For those who don't know me, my name is Matt Curto, and I've been in legal marketing for a better part of 15 years. A lot of you probably know me from Stretto and Best Case. I was there for a number of years, made a lot of connections, and basically I had left Stretto and now working with Sanguine. It's a free advisory group. Basically, what we're doing is we are helping with third-party vendor selection. We have a process of vetting and working alongside with a lot of the vendors, a lot of which we're talking about today. And we've built kind of a best-in-class portfolio of solution providers across many different areas. So legal marketing, AI-driven marketing, CRM selection, virtual paralegal services. And that's what we're talking about today is, mastering AI growth for bankruptcy attorneys, and then also your more traditional virtual receptionist service. And then as you're doing this and you're putting all this information out there on your website, making sure that you're staying compliant with cookies, settings, and the information on your website. We all hear stories about that. So kind of jumping into it, I'm going to start by introducing some of the speakers here today. You can take it away with Captain Compliance.
Good stuff. Thank you, Matt. I'm Alex. I'm the Chief Trust and Privacy Officer here at Captain Compliance. That's all we do is cyber compliance. It's very clear to me that the firms that choose to embrace AI are the ones that are going to grow the fastest. So what I want to talk about a little bit is AI compliance, which, to be frank, it's sort of like an emerging field in the US, right? Right as the technology evolves, so is the field of compliance. It's looking a lot like it does for privacy, though. So I would say maybe it's, 2 to 5 years behind where we're at with privacy compliance. But you'll notice that many aspects of good and responsible AI use are just new ways of applying existing principles, many of which are from privacy, especially those relating to notice and consent. So much like privacy, we're starting to see this patchwork of AI laws start to pass across the states. And they're coming at the state level once again, rather than federally. So there's a bit of just differences from one to the next. So there's a lot of different states that have laws in the works, and there's really 4 that have passed, and I want to talk about them really quick. I just want you to know what they're all about, whether or not they're applicable to you, and then I'll tie it up with some major themes. The first one you want to know about is in Utah. So Utah has passed the first significant AI regulation in this country. It's the only one that's actually active at this moment, and it's focused on Gen AI, so generative AI. And it's also focused on the disclosures that companies have to make to their customers if they're using it. So there's really 2 main scenarios where a company is required to disclose the use of their AI. So the first one is pretty simple. It's if somebody asks about it. Like if somebody asks you, then you need to disclose it. But more notably, you need to disclose your AI use in situations that Utah's law calls high-risk interactions. So there's a couple qualifiers here. So a high-risk interaction involves sensitive personal information, which for a bankruptcy firm, this could be financial data, and also some sort of significant decision-making. So this could also be financial or legal decisions, which could be relevant to a firm. So if you're operating in Utah and you determine that this law is relevant to you, it's just another reason to make sure that you focus on your AI disclosures and that you're being transparent with your customers. If you think back to that really cool Lucid demo that we just heard.
Hello.
Tessa, your AI legal assistant on a recorded line. Who am I speaking with?
Yes, you're speaking with Mark.
Nice to meet you, Mark. Can you tell me what type of bankruptcy or debt assistance you're looking for?
I don't know if everybody noticed, there was a little brief disclosure at the beginning of the call that you're interacting with an AI agent. That's exactly the type of thing that you want to make sure that you're doing. So next up, there's a trio of 3 more laws that are coming into effect in 2026. 2 of them are out of California, which is just no surprise at all. Here's the first one. So this is the Generative AI Training Data Transparency Act. And it's also focused on generative AI, and it basically amounts to a set of requirements around training data disclosures. So you can think of this as requiring companies to disclose what training data they used, where it came from, who owns it, and all of that sort of thing. So if you're building or directly training an AI system, you're going to want to have this on your radar so that you can document those sorts of details about the training data sets and your AI systems as a whole. The other law that's out of California may not be super relevant to this audience, so I'm just going to breeze over it, but I think you should know it exists. This is for if you're a provider of a very high volume generative AI provider. So if this is the case, there's certain requirements that you provide AI detection tools so that, deep fakes and that kind of thing can be detected, and also make certain disclosures. So this is probably more useful just personally. Like if you know that you're using these large AI models, know that the providers are required to provide these detection tools so that you can have a way to detect when content is generated by an AI. And then last but not least, the last state law that I want to mention is probably the broadest of the four. Colorado's passed this Colorado AI Act. And this is one that also has significant requirements for companies that run high-risk AI systems. So it's the same kind of idea as in Utah. These high-risk systems are basically those that make consequential decisions about individuals. So this is not going to be like your marketing copy or probably your basic, it's probably not your basic customer, chat sort of thing. This is for decision-making AI systems. So it's a long list of requirements. It's too many to even get into here, but just know that they're very involved. If you do have these sort of high risk systems that might be in scope for your firm, maybe you're using a tool that would qualify, just be ready to perform regular assessments of those systems, make sure they're disclosed and so on. And then to tie it all up, I'll go to my last slide here. So, that was like the general type of laws that's passing so far. Obviously, there's a lot more that are in the works, so there could be some differences coming up. The laws do tend to have pretty specific scopes, which is nice. I would say that the most significant way that you could mitigate AI compliance risk today is just focus on documenting your use of AI. Really should know if any of it is considered high-risk processing, especially under Utah today. And then make sure you're disclosing your use of AI to your customers. The general theme is that any of your normal privacy considerations, they should apply to AI. So that could be, very clear, specific notices and disclosures. It could be opt-out options for AI processing and decision-making and that kind of thing. So just keep an eye on the landscape. There's a lot more to come. Most of those laws are yet to pass. Thank you.
Appreciate it, Alex. I appreciate everybody sticking around. So take care. Thank you.